Welcome, everyone. Today's webinar is entitled, Do You Have Boundary Issues? Ethical Pitfalls in Multi-Jurisdictional Practice. If you have questions during the webinar, there's a Q&A button on your screen that you can use to ask the questions. That's the purple button in the middle. If you want a copy of the slides, you can use the resource button, which is the green button on the right. There's also a yellow help button, the question mark on it on the left-hand side, that'll address some common technical questions you might have, or you can ask a technical question using the Q&A button. Today's webinar is approved for 1 hour of ethics credit in California, 1 hour of professional responsibility credit in Illinois, 1.2 hours of ethics credit in Missouri, and is pending approval in Texas for 1 hour of ethics credit. Watch for pop-ups during the webinar. You must click on these to verify that you are watching. Our presenter today is Eric Cooperstein. Eric is Minneapolis-based. He's a well-known specialist in legal ethics. Eric is on the board of the Minnesota Continuing Legal Education, the Minnesota Lawyers Mutual Insurance. He's also a member of the ABA Standing Committee on Bar Activities and Services. Eric previously was a delegate to the ABA House of Delegates, president of the Hennepin County Bar Association, and chair of the Minnesota Bar Rules of Professional Conduct Committee. Eric represents lawyers on ethics complaints, fee disputes, law firm dissolutions, and other matters. Eric frequently speaks on legal ethics and law practice management, and we all have the good fortune today to benefit from Eric's expertise in presenting on legal ethics. Eric, the platform is yours.
Thanks, Dudley. Hello, everyone. Good to be with you today. Multi-jurisdictional practice is one of my favorite ethics rules that I love to hate. When lawyers find out what the rules are, lawyers who every day have contacts with other states, and it's just the ordinary part of their practice, and then find that the rules are actually not as clear as they thought they might be on what you can and cannot do in other jurisdictions. So I encourage you not to panic during the course of this webcast. I'll explain it all through and explain what I think that you should and should not be careful about. I like to start off this seminar with just a short hypothetical to make sure that we're all kind of on the same page as to what we're talking about. So this simple question is that for many years, you have represented a home state franchisor. When I talk about multi-jurisdictional practice, I use home state to represent a jurisdiction in which you hold a license. You could have more than one home state if you hold multiple licenses. For today's program, most likely we'll be talking about thinking of the lawyer who has one license in one jurisdiction. I use away state to indicate all those other jurisdictions in which you do not have a license. So you've represented a home state franchisor in employment matters. The franchisees, who are located in several states around the country, want your help in drafting employee handbooks for their local franchises. You would likely do most of the work from your home state office, but would occasionally also meet on-site with the franchisees and conduct on-site internal investigations when problems arise. Perhaps you would participate in mediations as well in those states. Is that okay? That generally is what we're going to be talking about today. I like to start with a little bit of overview of multi-jurisdictional practice. So 48 U.S. jurisdictions, including the District of Columbia, have adopted a version of Model Rule 5.5. Just a note in terms of the jurisdictions that this program is being authorized for CLE credit. Texas is one of the jurisdictions that does not have the Model Rule. Texas still has the older pre-2000 version of Rule 5.5. The interest in prosecution for MJP issues varies from one state to another. Some states are more aggressive about it than others. The landscape has changed a little bit, I would say, over the past 10 or 15 years in terms of disciplinary prosecution. We have a beefed up Rule 8.5 in our model rules now, which talks about when the rules of a jurisdiction apply to you, and 48 jurisdictions have adopted that. It used to be back, so at one point in time, I worked for the discipline office in Minnesota. That was back in the 90s. And back at that time, when a complaint came in from somebody about a lawyer who wasn't licensed in Minnesota, we would say, go complain to the state where this lawyer is licensed. This is not our table. That has changed. Now, I've been representing lawyers in private practice now for 14, 15 years. And it is not uncommon now when someone complains about a lawyer to a state in which the lawyer is not licensed for that jurisdiction's discipline office to investigate and issue discipline. So it has shifted. That is actually an interesting shift in terms of the policy goals, because the theory in part behind having a multi-jurisdictional practice rule, having restrictions on where lawyers go, is that discipline agencies say they're concerned. How do you prosecute? How do you go after rogue lawyers who travel from one place to another? And whether intentional or not, one of the things we've seen over the past decade or so is that actually jurisdictions where lawyers are not licensed are perfectly willing to go after lawyers and conduct their investigations and expect them to respond and actually to issue discipline against them. So it's not clear whether jurisdictions are handicapped in their ability to prosecute lawyers who go from one place to another. But that's one reason why we're concerned about these rules. Lawyers who would escape prosecution from one place, moving from one place to another. There is a notion that within 5.5, and you will hear this often stated by defenders of the rule, that we are trying to protect the public from abuse by unqualified lawyers and poachers. That is closely related to this idea of protecting the financial interests of the local bar, poachers being people who come from other states to take your business away. If you look at the whole Rule 5.5, and in the materials at the end, there's a version of 5.5 all in one place. In this presentation, we deal with the pieces of 5.5 one at a time. But if you look in that rule, you will see that Rule 5.5 actually says nothing about competency. Competency is governed in most jurisdictions by Rule 1.1, and every lawyer has an obligation, no matter where they are or where they practice, to be competent in what they do. So the idea that we are concerned about lawyers from other jurisdictions coming in and messing up our law is a little bit misplaced. We also have to consider that in a given state there are, well, I think in all of the states that are being authorized for credit in this program, there are literally tens of thousands of lawyers in that state. Any one of those lawyers, despite the way they may have practiced family law for the past 20 years, they could go out the next day and take their stab at a personal injury matter for a neighbor of theirs that they think is perhaps pretty lucrative. And there is no mechanism within the law other than Rule 1.1 to make sure they're competent to do that. So there's a big question in my mind and some of the other people who are critical of this rule as to why we think that someone who's practiced, say, personal injury law in another state is necessarily not qualified to do so in a state where they're not licensed. Of course, it's litigation. They'd have to be pro hoc in. But why are they thought to be presumptively not qualified when there are lawyers within the state who have never practiced in that area who have a license to do almost whatever they want in that area within the bounds of the rules? So it's not clear. The policy goals are kind of have thinned out over the years for Rule 5.5. In talking about multi-jurisdictional practice, I do want to point out that we have this ethics rule that we all have to pay attention to as licensed lawyers. You should know, if you're not aware already, that there are criminal statutes in many jurisdictions that govern the unauthorized practice of law. At one time, it may still be the case. In Florida, it was a minor felony to engage in unauthorized practice of law. Those statutes are mostly directed at people who have never been lawyers, but there are occasions, there's nothing about the statutes themselves that said that they could not be applied to out-of-state lawyers. Another risk, besides simply the ethics rules, is always the possibility of fee forfeiture. In a few minutes, I'll be talking about a famous California case, the Bierbauer case, which was the case in 1998 that launched the changes to Rule 5.5 that have given us the model rule we have now. And in that case dealt with fee forfeiture. And so lawyers should be aware that even if they believe they're within the ethics rules, a court may deny them their fee. There was a Virgin Islands case within the last 2 years where the Supreme Court in the Virgin Islands denied some Washington, D.C. lawyers their fee, even though those lawyers had never stepped foot in the Virgin Islands, when they filed their fee petitions in court in the Virgin Islands, they deemed them to be engaged in unauthorized practice of law, and they denied them their fees in that under their fee shifting statute in that case. And then lastly, keep in mind as we go through this that what you can do is different than what you should do, right? So I'm not talking about malpractice. You may go to another jurisdiction, start practicing law there. It might be permitted by Rule 5.5, but you may be woefully unprepared to practice in that area of law in that jurisdiction. Real estate is an area that comes to mind as something that is very specific by jurisdiction. That might be hard to figure out what the local practices and rules are. You could possibly miss something. Malpractice is kind of the flip side of what I said a few minutes ago about Rule 1.1 governing competence. That's how we govern competence in the ethics rules, but of course, I suppose malpractice also governs competence as to what lawyers should and should not do. So we're going to start out just with Rule 5.5a. The first part of the rule essentially says that a lawyer can only practice law in their home jurisdiction. And in that fairly simple sentence, there's two phrases that lawyers can glom onto. First is the practice of law. What does it actually mean to practice law? In a case I'll be talking about a few minutes ago, the only practice was the lawyer was negotiating on behalf of another party. And people like to say, well, is negotiation really the practice of law? I mean, that's, lots of people negotiate. That is true. What I find in looking at cases and about the practice of law generally and how jurisdictions define it is there are many things that when a lawyer does them, they're the practice of law, even though there are non-lawyers who do them as well. And I have found that does not seem fruitful at all to try to pick nits over whether a lawyer holding themselves out as a lawyer in a matter was engaged in the practice of law when they did something such as negotiate or draft a letter for somebody or attend a meeting or review some bylaws as a favor to somebody else. Most likely all of those things are the practice of law, and it is really unavailing to us in this discussion of multi-jurisdictional practice. Now, what does in mean? Not to be too Clinton-esque about it. I had always thought, and I think many ethics lawyers would agree with me, that I always thought that to be in a jurisdiction would mean only really three things. First is to be physically present in the jurisdiction. I am in Minnesota right now. I am fairly certain of that without getting into too much level 301 philosophy. I'm pretty sure that I am in Minnesota right now. And so I'm practicing law, not in this seminar, because this is not the practice of law, but I am this morning and this afternoon, I'm practicing law in Minnesota. I think we all accept it's something of a fiction, I suppose, but the concept that when you file documents in court, you are in that jurisdiction, you are appearing in that jurisdiction. And so as a function of law, I would say if you try to file a civil complaint or any other document in a court of law in a jurisdiction in which you're not licensed, I think that you are in that jurisdiction for purposes of Rule 5.5. The rule itself, we'll see this again later, but Rule 5.5 itself has another subpart B, that says that you cannot hold yourself out as being licensed to practice in a jurisdiction or establish a systematic and continuous presence in a jurisdiction. So by function of that rule, that would seem to define, for me, what it means to be in a jurisdiction. So although not physically in a place, you could have, if you for example, set up an office in an away state for the practice of law where you are not licensed, that would be a systematic and continuous presence that is prohibited by Rule 5.5. If you advertise that you were licensed to practice that you were able to practice in a jurisdiction in which you are not licensed, that would be holding out, and I think you would be considered to be in that jurisdiction where you are holding out for purposes of Rule 5.5. But there is a lingering question or there has been for many years, a question of, well, can you be in a jurisdiction by virtue of sending email to a jurisdiction, or I suppose for that matter, making phone calls, sending faxes, etc. Can that place you in another jurisdiction? And I had thought that the answer to that question would be no, until this little discipline case came along that I handled. This is the bane of my existence. I'm kind of forced to talk about this as a way of purifying myself. So in Minnesota, if a lawyer gets a private admonition, that can be, there's an appeal process. You first go to a board, a panel of a board that can either affirm or dismiss it. And then you have a right to appeal to our Supreme Court, and that's how it makes it there. And I'm talking about a Minnesota case because this is really the only and most recent case that really has an analysis of Rule 5.5 in the case. And there's been a lot of flack over this case since it came out in 2016. So the facts were that a Colorado lawyer had relatives in Minnesota with a legal problem. And the relative said, "Can you help us out here?" It was they owed like $3,000 some to like a condo association or something, and they were getting done to pay the debt, and they were upset. They felt like they were getting harassed, so they asked their son-in-law to help them out. So he contacts opposing counsel who's in Minnesota by email. They exchange roughly 20-some emails during the course of 4 months over a summer. Maybe there was a phone call mixed in there. They're not making any progress on resolving the issue. The Minnesota lawyer gets mad and complains that the lawyer is not licensed in Minnesota, which the lawyer disclosed at the very beginning of their interactions, and said that if I have to appear in court, I'll get local counsel. Minnesota lawyer is mad. He files an ethics complaint. Our Office of Lawyers' Professional Responsibility issued an admonition for a violation of Rule 5.5. And the disciplinary board panel affirmed on the premise that all elements of the case were in Minnesota and the case did not arise out of its Colorado practice. That arise out of is an allusion to 5.5b4, which we will get to in the course of this discussion. So in that case, the question presented is, well, the lawyer never left Colorado, so can you be in Minnesota by virtue of sending email to a state under our rule, which was the model rule? And so I said I would talk about Bierbrower, which is a 1998 case that predates this version of the model rule. And in Bierbrower, and this case was like an explosion amongst the bar for those of you who maybe had never had any contact with it before. In Bierbrower, there was a New York firm, and they had a California client, which had a dispute with another California corporation in California. And the dispute was headed towards arbitration, a non-court arbitration. In other words, this was a voluntary arbitration pursuant perhaps to a contract between the parties. And the case settled. And then the New York law firm actually had the case on a contingent fee. And before the law firm could try to collect its fee from the client sued the firm. The California client sued the firm for malpractice, the New York firm. And the firm then counterclaimed for their fees. And the California court looked at this and said, well, you're in New York, you're not in California. And we have a statute that says no one may recover compensation for services as an attorney at law in this state unless the person was at the time the services were performed a member of the state bar. And so the court said, you can't get any fees for the work that was performed in California. You can get some quantum merit for the work on an hourly basis that you did while you were in New York, but nothing for what was done in California. And so going back to that Minnesota admonition, the Minnesota Supreme Court relies on Bierbrower, despite it predating the revised model rule, and says, well, Bierbrower did analyze what constituted the practice of law in a jurisdiction by looking at the nature of the legal representation of that jurisdiction instead of focusing solely on physical presence. And quoted the California case where it said, a lawyer may practice law in the state, although not physically present, by advising a California client on California law in connection with a California legal dispute by telephone, fax, computer, or other technological means. And when I say the Minnesota Supreme Court followed this, is actually I actually was able to convince 3 justices of my position, but there were 7 sitting on the court that day. So that didn't dispense of the entire case, but the court said, well, no, we think actually you can be in another jurisdiction by virtue of sending email to that jurisdiction. There's very little guidance in the decision as to how many emails triggered. Is it a 1 email rule? Is it and must count for telephone calls, although the decision does not exactly say telephone calls, faxes. We made all the arguments you might think of about the fact that the emails travel through servers and the record. I didn't have the case below. I only had it at the Supreme Court. So the record below did not indicate whether the Minnesota lawyer was in fact in Minnesota. What if the Minnesota lawyer was in his cabin in Wisconsin when he got the emails? Would they both be engaged in the unauthorized practice of law? So as I said, that didn't dispose of the case, and the way in which it didn't dispose of the case is for the most part helpful to everyone. We'll get to 5.5C4, which explains how and when you can be in other jurisdictions. But that rule or that suggestion that a lawyer could be in another jurisdiction by virtue of sending email still stands here. And because it's really the only court, I think, to have interpreted directly that provision, it's probably relevant to the interpretation of the model rule in other jurisdictions as well. So let's move on to the other parts of the rule. And I'm going in order here. We really want to get to 5.5C, but we're going to stop off here at 5.5B, which is that rule that says that a lawyer may not establish an office or other systematic and continuous presence in another state or hold themselves out as able to practice in that state. We're stopping here because this is one of the areas, given the gloom and doom I just painted for you, this is one of the areas where there actually has been some liberalizing of the rule in recent years. So this is the rule that said, as I alluded to earlier, that you cannot establish an office in another state, and previously would have said you also cannot, work from another jurisdiction where you're not licensed. Yeah, in other words, this rule used to say only you have to be somewhere and you have to be in a place where you're licensed. So if you just imagine people who live in cities that border other states, right? Very common on the East Coast. You could actually live in Indiana and work in Chicago, I suppose, a little bit of a commute. There are lawyers, you can be in St. Louis or Kansas City, and work in one place and be at home in the other. And then at some point you decide, pre-pandemic, you know what, I worked at home, I'm going to work at home a couple of days a week because I get more work done. And at some point you convert all the way over to working you're working in Kansas City, Kansas instead of Kansas City, Missouri, where you're only licensed in Missouri. Can you do that? And this is also a big problem for lawyers who needed to move either because their spouses got new jobs or they had ailing parents that needed their care. You can imagine a lawyer who has a nice little private practice in one state or even works for a larger law firm in one state, needs to go to another state for whatever reason. And personal, they like the weather there. Like that's not actually a good reason. But let's just take the lawyer who needs to take care of an ailing parent, and they just want to take their laptop and their cell phone, and they just want to just go there and just do all the same work they were doing in the state where they're licensed in their home state. Well, previously the rule was pretty clear that you could not do that. You could not be 100% of the time in some jurisdiction where you're not licensed practicing law, even though that was invisible to the public, that you were actually someplace else, especially in a more sophisticated firm that has the technology to say, have your phones or voice over IP, right? You take the phone, you plug it into your computer at home. It looks like it's ringing in Missouri, even though you're in Montana. And before the pandemic, there were several jurisdictions, including Minnesota, that amended their rules to say you could do exactly that. If a lawyer comes here, if a lawyer comes to our jurisdiction and is only going to practice the law of their home jurisdiction, which is a difficult concept to get your head around, the idea that states have special laws and only people licensed to practice in those states can practice, can research and opine and give advice on those laws. Nevertheless, these jurisdictions said this is a reasonable expansion of the rules. They're all up on your screen here. And this all happened in 2015 to 2018, roughly, where these jurisdictions changed. And then the pandemic came, and as we know, lots of people went to work remotely, either at their homes over borders or actually in states further away than that. And the ABA kind of hopped on this, relatively quickly for the way in which ABA formal opinions are typically issued, and issued an opinion last winter in January, in November, December, that actually 5.5b is not quite as expensive as you might read it to be. And that it does not, in fact, bar remote practice in another jurisdiction as long as a lawyer is not practicing the law of that state. Again, there's that concept. Or holding out as able to practice in that state. So basically, all these lawyers who were worried that they might be in violation of the rules because they were working remotely in a jurisdiction in which they were not licensed, now have all gotten something of a pass. It's a pass with a catch, because there's nothing in the ABA opinion that says that you can cure any impression that you're in the wrong jurisdiction by disclosures. So if you're, for some lawyers, for example, if I were a Minnesota lawyer and I moved to Wisconsin where my cabin was to work permanently because I found I got so much more work done when I was at the cabin, well, so now you have a little problem about where can you receive mail. You can receive mail in Wisconsin, obviously. But if you tell clients to mail you checks in Wisconsin, or if you tell parties who just refuse to send you electronic documents and say they have to mail things to you, if you give out your address, well, now you're not stealth anymore. Now it's clearly project that this is where you're located in Wisconsin. It's not hidden anymore. And so it's a little bit of a flaw in this opinion. But nevertheless, this backing off of the idea that just because you are physically located in another jurisdiction, your home, for example, and that's the only place you practice from, that 5.5b preclude you from doing this is an expansion of the law. And I think that overall, it's an important and a healthy expansion. I do have concerns about this idea of these restrictions based on practicing the law of a particular state, because well, as I like to say somewhat sarcastically, why does the law library have all those books if we're never allowed to look at the law of another jurisdiction, if we're not allowed to advise a client? And those of you, I think we have quite a few lawyers. First of all, I know we have some in-house counsel on the line today. I know we have some lawyers from large firms listening today. Is your client actually supposed to hire 10 different lawyers to advise them on which of 10 states would have the best, say, employment laws, would have the most friendly employment laws for them to open up their new factory? Really? Is that what we're going to say? But you would be advising them on the law of other jurisdictions. And if you take this concept if you extend that concept, well, then it seems there's something wrong with advising lawyers on the laws of other states. It seems like that can't be. Like a lot of things with Rule 5.5, it seems like, well, how could that be? And I think this concept of prohibitions on practicing the law of a particular state when you move there, they're just not logically sound in terms of the way law is practiced. And particularly, and this is true of a lot of the problems with 5.5b, it's not what clients want. Clients, and one of my themes in talking about multi-jurisdictional practice is that clients want lawyers who they trust, number one, and who they think that will do their work efficiently and well, right? That's clients' number one goal, and I imagine there are very few clients who really care where a lawyer is located when the lawyer is doing the work. Now, a client might care if a lawyer pretends that they could, take on action that's going to be litigated in some other state, and that the lawyer could go into that away state and litigate that case when that's not the fact. You'd have to be admitted, you have to hire local counsel. Not disclosing that to a client could create a problem. But for the rules of professional conduct sometimes forget that perhaps more than half of all the lawyers practicing law are transactional lawyers who don't go into court and don't have to go into court. But the rules are clearly geared towards litigators. But the world of transactional lawyers clearly is doing deals, negotiating, having contacts, discussions, meetings with clients and parties and third parties all over the country. And one case can easily have clients whose home office, if you will, if they're corporate clients, is in any one of several jurisdictions. You could have multiple clients. And so this idea that you can't or shouldn't advise clients on the laws of another state, somewhat bankrupt to me. But I don't think there's a case out there as of yet that actually has disciplined a lawyer for doing this thing of so-called practicing the law of another jurisdiction. There oftentimes are other, when a multi-jurisdictional practice case comes up, there's often other facts that are driving the case other than whether the lawyer advised. Although I do know there's been some talk on, there's a nationwide association of ethics lawyers called the Association of Professional Responsibility Lawyers. And there is a lawyer out on the East Coast who is defending a case in which their disciplinary board is accusing a lawyer of unauthorized practice of law because he interpreted some New Jersey corporate laws. And my response is always, well, how can they prosecute that case? Don't they have to interpret the laws of New Jersey in order to prosecute that case? And it's a pending case, and there's, kind of no clear answer at that point. Okay, let's move on to the place where you all really want to be, which is Rule 5.5c, which talks about when a lawyer can practice temporarily in another state. And could be any one of the things that I've discussed so far. So being temporarily in another state could pertain to being physically in another state, such as the easy case when you're on vacation in another state and you're still working, much to your family's consternation. It could be that you have to file documents in court in another state. It could be that you have to do other things in the state. So 5.5c has 4 parts, and the first 3 parts are pretty patently obvious that they should exist in the rules. So permission to associate with another lawyer in that away state. You could be authorized by law to appear if you apply for pro hoc vice status. That's pretty easy as well. Part 3, 5.5c3, if your work in another state is reasonably related to a pending or potential arbitration, mediation, or other ADR proceeding in this or another jurisdiction, and pro hoc vice is not required. So this would be the Bierbauer rule to fix that, to say, no, it is ethical for you to go and do a mediation and arbitration in another jurisdiction. This idea that there are places where pro hoc vice is not required comes up a lot when you have to appear before administrative agencies, which are not courts, but may have court-like structures. There may be adjudications, right? There may be administrative law judges and the like. There are not really clear rules or cases on this. I will tell you that the lack of cases suggests that the agencies often, that they haven't made an issue of it. I think oftentimes lawyers themselves go ahead and get local counsel for these proceedings, though, so it may be that it just doesn't come up. And I will say, given the world I operate in, when I need to appear in another jurisdiction on an ethics case, on a discipline case, I typically call and ask them first, what do you want? In South Dakota, they just want you to have your sales tax license. That's all they really care about. I called to another state, and they weren't completely sure, but they said, yes, you can send us this response on behalf of your client. My client was licensed in both Minnesota and this other state. So this is a really vague area of the law of what you can do when pro hoc vice is not required. And there's also the problem that, well, if you ask and you're told no, well, then I guess now you need local counsel, right? And so there is a question about asking for forgiveness rather than permission. But it's 5.5c4 that's really important to lawyers who do work in other states. 5.5c4 says that you can be in another jurisdiction temporarily if the matter in the other state arises out of or is reasonably related to the lawyer's practice in her home state, right? So this pertains in large part to all the cases that you are already doing, right? So this is the cure. The idea is that you are temporarily in these other jurisdictions. Now, I know you have questions about the natural thing is I have questions about, well, how far does temporary go? How far can we extend that? And I have this fanciful little hypothetical here, mostly to show you how little we know about what temporary means. So if you are a lawyer licensed only in Minnesota, which of the following would constitute the unauthorized practice of law? Working on a brief and answering client emails while the lawyer's on a 2-week vacation in California. Working 2 days a week from home in Hudson, Wisconsin. Working on all client matters by spending January through March at your condo in Scottsdale, Arizona. Moving to Fargo, North Dakota, but working on only matters for Minnesota clients. Or 5, living in an RV and practicing law while driving all over this great country of ours. Which is ironic because I run into so many lawyers lately who are doing big trips to national parks with their family this summer since we're all itching to get out. So some of this, so there are not really any, there's not great guidance on this. I think all lawyers would agree that temporary includes being on vacation and working while you're away. I'm going to just pop down to 3. Can you be away for 3 months? Now, I should change this slide because Arizona is now one of those states that says, well, you can come here and just do work on your Minnesota law matters and be stealth. So we really should change that to Florida. Can you go to Florida for 3 months and work on client matters? Is that sufficiently temporary to meet the terms of the model rule? We don't know for sure. I personally think 3-4 months is probably okay. I would say, though, that 6 months, if you think that you're going to take 6 months in another jurisdiction and even maybe declare yourself as a resident of that state for tax purposes, I think it's unlikely that the jurisdiction is going to find that you're still temporary if you're there for 183 days during the year. So I think there are some limits to what's temporary. So 2 and 4 is this pandemic-related problem, that we've now in part solved, although number 4 is probably only allowed if you are going to be stealth in North Dakota, provided, of course, that North Dakota agrees to follow the ABA guidance on this issue. The ABA opinion is not mandatory authority anywhere. Most jurisdictions will follow ABA opinions unless there are occasions when I've seen jurisdictions stake out a territory against what the ABA has kind of come down with. But so assuming you could get North Dakota to follow that provision, you probably could do number 4. I think working 2 days a week from home in a border jurisdiction is probably temporary. At least that's what I would tell people if they asked. But it's not 100% clear. And remember, it's also not at all clear who it is we're protecting by saying that there might be a question if you're working 2 days a week from another jurisdiction. So that's one sense of temporary. What I said earlier about how 5.5C4 protects you in the work that you are kind of routinely doing every day on matters that cross jurisdictions, I think is very helpful. But what we don't have, for example, is we don't have a rule that says, so let's say you're in, pick a state, Missouri, and you have a client you've represented for years, and that client decides to move all of their offices to Tennessee. But they love you. You do great work. They still want you to be their lawyer. And so they move. You continue to advise them. You go there for meetings. Maybe you're their corporate counsel. Maybe you go there for board meetings. Maybe you are their employment counsel. Maybe they fly you in to do various types of things. Maybe you work on types of matters, compliance issues, and you need to go to actually be on site and touch things on a regular basis to make sure that all the rules the company is supposed to follow are being followed. It does seem to me that there is some point at which you are no longer, that you would be hard pressed to really defend an assertion that, well, it's only only there temporarily. It's repeated. It's not clear whether temporary is the opposite of repeated but short durations. So this is one area where the rule is very unclear. My default position wherever possible, provided the facts support it, would be to say that in some way or another, whatever it is you're doing in another jurisdiction is temporary. But there may be limits on whether you can assert that or not. The other thing about 5.5C4 is that It turned out in that little Minnesota case that I had that it was not quite as expansive. I mean, I think that 5.5c4 was meant to be a catch-all. It was meant to address every other situation where logically you'd have to be in another jurisdiction, but it's not the way it gets interpreted. I'll stop over by this rule for a second. So what can you do under the rules, right? There's a whole bunch of things you can do. You can represent your home state clients in your home state. I'm not saying anything clever there. You should be able to advise clients of the laws in other states. I believe that's true despite the East Coast case I told you about. You should be able to tell clients of the laws in other states because you are not in those other states when you just are reading the law and advising people on it. You could interview witnesses, take depositions, negotiate in other states for your home state client. If you have a corporate client, you should be able to do business in other states, provide advice, obtain permits, deal with government officials. You should be able to conduct ADR in other states, and you can appear in court in an away state if you're associated or admitted with a local lawyer. And of course, you also can represent clients from other states in matters that take place in your home state, right? And in fact, a lot of times you have to do that, right? Someone who has to litigate in Missouri, even if they're not a resident there, instead of getting local counsel, they just want to hire a Missouri lawyer, right? That if you're in a car accident in Missouri, that's what you do. If you have a corporation that has business in Missouri and your corporation is elsewhere, you might want to hire a Missouri lawyer to handle that matter. So, and the reason I raise that kind of self-evident point is to say that 5.5 itself does not say anything about where the client is located. People read that into the rule as if it matters where your client is, but the language of the rule itself does not actually say that it matters where your client is. Obviously, there's a problem in my Colorado case, and it's been a problem in some other cases. There was a California company that was doing something sort of like debt settlement work, and they were trying to do it nationwide. They had a client in Ohio. Ohio is very aggressive on the enforcement of unauthorized practice of law prohibitions. And without analyzing the ethics rules at all, Ohio sanctioned the California lawyers because they had an Ohio client for a matter that was being negotiated for their benefit in Ohio. And between the lines, there was no connections to California, so this must be the unauthorized practice of law. And the lawyers from California, they didn't exactly default, but at some point they just decided, look, if you read between the lines, it was like they just decided to pay the $2,000 fine and walk away because it wasn't worth the cost of litigating. So states will take this attitude about what you can do in other states. But there is still a question of what is the scope of Rule 5.5c4, particularly when it comes to new matters. I've been talking so far about matters you already handle. Will 5.5c4 allow you to take on a new matter? So I have this little two-part hypothetical. It's paraphrased directly from the restatement of the law governing lawyers. It's, of course, a very helpful resource. So you have Marks. Marks is a licensed Minnesota lawyer who practices estate planning from her only office in Minnesota. And Rich is her longtime estate planning client. Rich moved to Florida last year. Rich called Marks from Florida to ask her to prepare a codicil to his will. Marks prepares the codicil and takes it to Florida to have Rich sign it. Is that okay? That should be a pretty easy yes. Clearly Rich's client from Minnesota. There were sufficient contacts beforehand. I think you can easily say under 5.5c4 that arises out of or is at least reasonably related to Marks's practice in Minnesota. Okay. Part two is where it gets a little bit sticky. So while Marks is in Florida, Rich introduces her to his friend Sonny, who's heard about Rich's estate plan, and whatever Marks has, Sonny has to have. Whatever Rich has, Sonny has to have. And so Sonny wants Marks to draft a similar estate plan. Marks agrees, returns to Minnesota, conducts some legal research about Florida law, prepares the documents, confers with Sonny by phone and letter, and then flies back down to Florida to have Sonny execute the documents. Did Marks's representation of Sonny constitute the unauthorized practice of law? The restatement says no, and I agree with that because the restatement says that this would still arise out of or be reasonably related to Marx's estate planning practice in Minnesota. It flowed directly through. And this is logical to me because, of course, this, as so many of us know, this is the way we get clients, right? One case leads to another case, which leads to another case. You develop an expertise in an area. Your client refers you to somebody else. Somebody wants you for your expertise. When Minnesota looked at this rule, though, in that case with the Colorado lawyer, they saw 5.5c4 as being much narrower than what at least I would have thought it would be. And this is also kind of a, well, it's a warning, I suppose, to other jurisdictions of the exact same language in their Rule 5.5c4 because we used to have the model rule language. So the court looked at this, this Colorado lawyer representing his in-laws and the fact that, everything was in Minnesota except the lawyer. And the court was trying to figure out, well, how expensive is 5.5c4? And they took a look at the comments. And the model rule comments, this model rule comment 14, talks about the types of things that might be reasonably related to the lawyer's practice in their home jurisdiction. And they go through a whole list of things. And, there could be a previous client relationship, there could be this, there could be that. They go through a whole list. And the only thing they come down to is right at the end of the comment, this quote, the services may draw on the lawyer's recognized expertise developed through the regular practice of law on behalf of clients in matters involving a particular body of federal, national, uniform, foreign, or international law. And one small irony in this case is that the lawyer, the Colorado lawyer, actually did a lot of debt collection work. He had an environmental practice, but he also did, he's licensed in a bunch of jurisdictions, but not Minnesota. And he actually had, in the course of his work, he had actually used some debt collection. So he had some knowledge of debt collection, but the court couldn't find anything in comment 14, including this nationally uniform idea. And in the end, the Minnesota Supreme Court said, well, when you represent your in-laws on this debt collection matter, that's not reasonably related to your practice back in your home state. And so they upheld the private acquisition, which was, well, a lot of people flipped out over the decision. I would just say locally, I got a lot of calls. Because what it means is, if you take that to its natural extension, what that means is that when your adult child has a landlord-tenant problem in some other state they live in, you probably can't call up the landlord and negotiate on behalf of your kid because you're not a landlord-tenant lawyer. And that would be the practice of law. You can, if your mother or mother-in-law is in a nursing home and having a problem in some other jurisdiction and you need to talk with them and want to cite some law to them about what they're doing wrong, if you're not a nursing home lawyer and if nursing home law is not nationally uniform, then you probably can't do that. Isn't that odd? And it also raises questions about, so let's say you've developed, and this is, the practice law of the last 20 years has become much more niche-y, right? Everyone has their hyper specialty. And because you have clients with that specialty, your clients, they all belong to associations. There's actually something like 22,000 different trade associations in the United States. And they have local conferences and national conferences. And you get invited to speak at the local conference, and then you get invited to speak at the national conference. And you meet people, and you talk to a lot of people. And then you start getting calls. People ask for your business card. They think you're intelligent. Go figure. So you get all these calls. And so you have to, there's a question about, well, do all those new client contacts, does that also arise out of, or is it reasonably related to your lawyer's practice? I would say yes. But in going through this whole Colorado case, we kind of realized in Minnesota that there were flaws in the rule. And so so what happened was the court actually invited us to fix the rule to take care of this family and friends problem, and that's what we did. We were able to make 2 amendments to our rule. So Minnesota's rule is no longer like the model rule in other jurisdictions. And I don't think any other jurisdiction has these exact amendments to them. These all came into effect in 2019. So first, we used a family and friend. We got a family and friends exception. I really wanted to have a client exception as well. So if you had a relationship with a present or former client, I wanted to take them out of 5.5 completely. And we got objections from our discipline office, and the court wouldn't go that far. But they would go so far as to say that, so as you can see, the language of this rule says, doing work for family members is now completely taken out of our rule. You can really, I think you can do almost anything you want now, representing, but this, of course, all 5.5 rules are really, the hope is that every jurisdiction would adopt them, right? Because what our rules say is what other lawyers coming into Minnesota, what your Missouri rule says, that has a similar language, says that this is what other lawyers can do coming into Missouri. Well, if everybody has the rule, well, then we know it's equal. So this actually talks about what happens if another lawyer like the Colorado lawyer comes in to do this work. It would be permitted now. In Minnesota and Wisconsin are the only two states that have a safe harbor in their rule that says, well, if you, Minnesota lawyer, go and do in another state something that would be permitted for someone to come do here, we won't discipline your Minnesota license over it. You could still get disciplined by the other jurisdiction. And if it was public discipline, I suppose it lives on the internet forever. But your Minnesota license would be safe. So that's another quirky thing about our rule. And again, I think there's only two states that have that safe harbor. But the important thing we did with 5.4, which really is helpful to lawyers, is that, and this is helpful to all of you who come to Minnesota on this basis and have Minnesota clients, is the Second Amendment that says such reasonably related services include services that are within the lawyer's recognized expertise in an area of law, developed through the regular practice of law in that area in a jurisdiction in which the lawyer is licensed to practice law. So that's for all these niche areas that we have where we develop contacts and we get a reputation and we generate business that way. We were concerned that there really is no such thing as a nationally uniform area of law. I mean, even when we discuss this amongst ethics lawyers, we talk about, well, what about ethics? Is ethics nationally uniform? I mean, most states follow most of the model rules. Is that nationally uniform? Does that mean under the comment under comment 14 to 5.5 that extends 5.5C4 to me and every other jurisdiction that has that rule? It's not clear because nobody defines what a nationally uniform area of law is. If your state has the uniform probate code, but you've amended it, is the probate codes are, the probate is very local by jurisdiction, but there is a uniform probate code. So is that a nationally uniform area of law? Nobody knows. The comment really was not helpful at all. So we managed to get this amendment through at least to fix this part of the rule. So as we come toward the end here, so I just want, and for those of you itching about federal practice and in-house counsel, I'm coming to it. We're just going to stop off quickly and talk about our original hypothetical, this thing about doing the work for the franchisees. Well, this should be squarely within 5.5C4, this type of thing. You should be able under 5.5C4 to be temporarily in another jurisdiction. It doesn't address that problem I mentioned about, the client moving to another jurisdiction and doing work regularly and routinely for that client. No, I don't think anybody's really addressed that. There are some other cases, and there's a set of materials where I have a sampling. There were not a tremendous number, I would tell you, of multi-jurisdictional practice cases in total. I mean, if there's, if there's 30 or 40 cases that address Rule 5.5, I might even be surprised about that. Certainly there could not be much more than that. These are the types of things that they come up in somewhat bizarre ways. Because some of you might be sitting there thinking, well, whoever complains against this? Well, like the Minnesota lawyer who was mad, I had a lawyer's ex-spouse complain that he was going to depositions in Kansas, which is clearly permitted, but nevertheless, ethics complaints can come from odd places. And usually with 5.5, your most likely complainant is going to be not your client, but a lawyer from another jurisdiction who is mad that they perceive you taking the work away from that lawyer. And so, I don't know if I make a big splash about being in other jurisdictions, but this type of work should be fine under 5.5C4. And just as you think about 5.5, you just want to keep on mind, is this temporary, and is this arising out of or reasonably related to my practice? You may find exceptions. You may find things that don't fit neatly, even an expansive reading of 5.5c4. But that is your kind of those are kind of your marching orders. That's what you're thinking about when you're in these other jurisdictions. Is am I temporarily there? And if you can satisfy this yourself that you're temporarily there, that should be just fine. So let's talk for a moment about federal practice. The model rule allows a lawyer licensed in a home state to provide legal services in an away state that are services that the lawyer is authorized to provide by federal law. This is an exception of 5.5b. So you actually can set up offices. It's very common, for example, there are immigration lawyers all over the country who practice purely federal immigration law. And generally, I get no questions about that from my discipline office. I haven't heard about any other disciplinary offices questioning the idea that a lawyer licensed in state A can go open up an immigration practice in state B, practice only federal immigration law without running into any multi-jurisdictional practice problems. There is a Michigan case that says that bankruptcy falls into the same area. It's a little odd to me because I know that in bankruptcy, oftentimes, especially in a 7, you have to figure out whether state or federal exemptions apply. And so it seems to me that you are, reading state law. Be careful. Securities law. I've had some success with in-house counsel applying for the bar in a new jurisdiction where maybe they've moved around a couple of times, and in one of their moves, they didn't apply to the bar in that state. So they moved from, say, California to Kansas to Wisconsin. And they were licensed in California. Then they spent 3 years in Kansas. Now they're in Wisconsin. They want to apply to the Wisconsin bar. And Wisconsin's asking, well, how were you not engaged in unauthorized practice of law for the 3 years you spent in Kansas? And in a couple of cases I've had, at least for our discipline, for our bar admissions agency, the lawyer's work was all in either federal compliance laws or federal and international privacy laws, which of course is a big area of work for in-house counsel legal departments. And that was sufficient, at least for the bar admissions authorities, to let those lawyers into the practice. So there are some areas you can practice. You may want to check your language, though, in your jurisdiction. The model rules language says authorized to provide by federal law. And there are a lot of federal laws that explicitly authorize you to practice in other jurisdictions. I mean, Social Security doesn't even require you to be a lawyer, and there may be a couple others that have their own rules of professional conduct that will authorize lawyers to just have one state license and work wherever. Our rule and a couple of other those states that I listed that have softened their rules on where you can open an office, a couple of us have changed the rule to say that in 5.5d that the work exclusively involves federal law. So it doesn't have to be authorized. It just exclusively involves. And if you think about it, there's a difference there. And so you can design your practice yourself. You could do only federal tax law, I suppose. I don't know how hard it would be not to practice any state tax law, but you could partner with somebody who does all the state law work. And if you're very careful, you might be able to, that might be permissible. And so when you're practicing the 5.5d, you don't need to be associated with another lawyer. You don't need pro hoc fiche admission. And then, for in-house counsel, as I've just kind of mentioned, the rules apply to in-house counsel. And lawyers have been disciplined for practicing in the jurisdiction while they were not licensed. The law is pretty good on protecting the attorney-client privilege as long as the lawyer is licensed somewhere and the corporation is not aware that the lawyer is not licensed in their jurisdiction. But if for no other reason than that you can't predict the future and you may move from one in-house counsel position to another, it's probably wise to get at least what's called an in-house counsel license. In some jurisdictions, it's easier to get a license if you're practicing only in-house for a corporation. You don't have to go through quite the same character and fitness requirements. You can get it quick. You can get admitted quicker, and it's designed to accommodate in-house counsel. We've lost that particular distinction here over the years because we've made it easier in other respects to be admitted by waiver. But if you're in-house counsel, it's important, and if you are a general counsel, you really should have a practice that somebody checks on everybody's licensure status on a regular basis. You could be responsible for unauthorized practices of law as a supervisor if you don't watch out for your employees. And I think that takes us just about, they told me, don't go more than a minute short. So the other thing, since I do still have a couple of minutes, we can go a little bit beyond 1 o'clock. I won't be won't be offended if people have to log off beforehand. But I will say, so I'm on a committee at the Association of Professional Responsibility Lawyers, and we have been working on and off for about the last 1.5 to 2 years on trying to come up with recommended amended Rule 5.5, trying to change 5.5 to help it reflect the reality of lawyers' practices. And to put it succinctly in the time we have left, what we are really trying to think of is a driver's license type model of practice, where lawyers would be licensed in one jurisdiction, and as long as you were in good standing in one jurisdiction, you'd be free to do pretty much whatever you wanted in other jurisdictions with disclosure. We've landed on a concept that lawyers should just simply, we should all just disclose where we're licensed. Isn't that easier? Is that so hard to put that in an email or in your letterhead, licensed in X state? And still the pro hoc vice rules would apply, and still you have to pay attention to your competency. But the idea that you wouldn't have to only be temporarily in another place. You could use, I realize a law license is a little bit more sophisticated than the driver's license, although lawyers who are incompetent at least less often kill people. But just the idea that if a jurisdiction, the jurisdictions are very similar nowadays. You know, there are 30-some jurisdictions who all give their admittees the same bar exam, the uniform bar exam, and very few jurisdictions have any special requirements for their own states. So our new lawyers are not being admitted with special knowledge of the jurisdictions in which they're being licensed. And so there is a lot more uniformity in the law, and we could take away a lot of this mystery over multi-jurisdictional practice if we could move to something that looks like a driver's model. Now that will likely take years to push through various systems to see if we could get the ABA to agree with us and make some amendments to those rules. But that's what some people's thinking is now about how to kind of fix these rules so they make more sense to lawyers. There were just a couple of questions. It's really hard in a presentation like this to read questions and answer at the same time. I will answer those questions after this webcast is over. And I think with that I will turn it back to you, Dudley, to close us out.
Thanks, Eric. Very interesting. And thank you to all of our attendees for participating in the webinar. Please complete the survey found on your screen. It should pop up automatically at the end of the presentation. And this concludes our presentation for today.